let's talk a little bit about rights of the accused. A lot of our Bill of Rights is aimed at protecting the rights of people that are accused of crimes. If you remember when the Constitution was written, our founding fathers really had a fear of government taking advantage of its citizens. That means maybe accusing them of crimes they didn't commit, not giving them the due process of law to adequately defend themselves. So in the Constitution, we wanted to write those things to make sure that people are absolutely 100% protected. So let's start with some of these amendments. The Fourth Amendment protects people from illegal searches and seizures. So again, this is a really powerful, strong amendment that protects your right to privacy. Anywhere that there's a reasonable assumption of privacy, a police officer has to have a search warrant in order to make an arrest, to find evidence. So, for example, like your house, that is, you have a reasonable assumption of privacy. A hotel room, an office, all of those things you have a reasonable assumption of privacy. Now, places that you don't would be things like your automobile. There's no really reasonable assumption that you have privacy when you're in your car. So if a police officer would like to search, they have to go to a judge, they have to get a search warrant, they have to have what's called probable cause, meaning there has to be a reasonable there's something to lead the police officer to believe that you have something incriminating within your home. So you can't just say, I don't like the look of that guy. Like, he seems like he's guilty. There has to be a little bit more. Like, we have a witness that said he has stolen Pokemon cards in his house or something. I mean, we have to have some sort of probable cause that leads you to believe that the person has evidence inside their home or inside their office or someplace that have a assumption of privacy to get a search warrant to go in and do that. Now, there are exceptions. There are opportunities to make warrantless searches. So, for example, if somebody is going to get rid of evidence, like if that suspect knows as a police officer that I'm coming after him and that evidence, and they're going to move it or they're going to destroy it, then I can go ahead and make an arrest or go ahead and search without a search warrant and explain it to a judge at a later date, explaining that the evidence was going to be destroyed. If it's in plain view, obviously I'm looking right at it. I'm like, wow, there's a bunch of stolen stuff right there. I don't have to get a search warrant. It's right in front of my face, for sure. If somebody has a probable cause that they've committed a crime, I can do what's called the Terry test. So there's a Supreme Court case, Terry versus Ohio, where you can, as a police officer, pat somebody down if you think they have a weapon which they committed a crime with. Automobiles don't have to have warrants if you think they have used that automobile in a crime. If somebody said they saw a red Toyota Corolla fleeing from an armed robbery, and somebody's driving a red Toyota Corolla, I can pull that over and search that car to see if they have stolen whatever, Pop-Tarts or whatever they took. So there are definitely some exceptions for the search warrants. Now, you have to go through the right procedures, like I said, to get the evidence. If you do not, and you did have time to go get a warrant, you don't meet those exceptions. The Supreme Court has been pretty consistent in saying that evidence cannot be used in a court of law. The Supreme Court case in the 1960s, Mapp versus Ohio, established what's known as the exclusionary rule, meaning if you didn't get the evidence under the right pretense with the stuff listed on the search warrant, then they can kick that out of court. They can exclude that evidence and not use it against you. Some things that need to be on a search warrant are things like where in the home you're going to search, how long are you going to search for, what exactly are you looking for. So it's not just a wild goose chase, like I'm looking for criminal stuff. Like I have to have a specific thing. I'm looking for bomb parts, or I'm looking for drugs, or some specific thing that I had to spell out to a judge. Okay, so search and seizure is a real big one, for sure. The Fifth Amendment also is a pretty big protector of the rights of the accused. Now, there's a couple parts of the Fifth Amendment that we're going to talk about. For example, Fifth Amendment protects you against self-incrimination. So you do not, as a witness in a trial, have to incriminate yourself. So if I'm testifying, I can plead the Fifth if they ask me a question that's going to make me guilty in a criminal investigation. So, for example, if me and our pawn are out one Friday night and something happens and we're involved in an incident and I'm with him and he does something crazy, like burns down the 7-Eleven, and I was there, and they ask me, like, hey, did you steal something from the 7-Eleven? And I'm like, oh, I stole Twinkies. I could plead the Fifth Amendment on that one because answering that question would incriminate me to committing a crime. A lot of times what a prosecutor would do is they would grant me immunity, meaning that I could admit everything that I did wrong and they've already promised me they're not going to convict me because really they don't care if I stole the Twinkie at that point. They want to get our pawn because he burned the 7-Eleven down. That's a far bigger crime. They would rather have me go in there and spill my guts than, convict me of stealing a Twinkie. It's not really as big a deal. The Fifth Amendment also talks about double jeopardy. So double jeopardy is very simply, you cannot get charged by the same court with the same crime. So if I commit, like O.J. Simpson is a great example. O.J. Simpson was charged with committing murder in a criminal court. He was found not guilty. But the families of those people that he was accused of killing, or the one family that he was accused of killing, sued him in civil court for wrongful death. It was the same action, the same act, but it was a different court. So it didn't violate double jeopardy. What double jeopardy is really saying is if they think I committed murder and I went to trial and I was found not guilty, all right, great. The state can't say, we're going again, we're going again, we're going to get him. And they try me again and not guilty. And we're going to go again. And they keep trying me until eventually they find the right combination of people that are like, well, if they keep going, he must be guilty. It's to prevent the government from just continually going after somebody, wearing them down until eventually you're going to put them in prison when they really didn't do it. So double jeopardy is a means to protect people as well. The Fifth Amendment protects criminals who confess to crimes without a lawyer present. This was kind of established in the Supreme Court case Miranda versus Arizona in the 1970s, I believe. Remember, Miranda versus Arizona was the Supreme Court case that said police officers have to read criminals or people charged with a crime their rights. So they have to be made aware that they can get an attorney. They have to be made aware that they can stop questioning whenever they want. They have to be made aware that everything after the time they're arrested is potentially going to be used against them. So if they said, like, oh yeah, I definitely stole a bunch of stuff, that's going to be used at the trial. So they have to know that everything from this point on that I say is fair game to use at a trial. And everything from this point on, I can say, like, stop, I want a lawyer, give me a lawyer. I can say, stop, I don't want to answer any more questions. You're badgering me, I need to collect my thoughts. So they can, the criminals, there are people accused of crimes, I should say, have rights too. So even though Miranda versus Arizona was a confessed rapist, he has to be made aware of his rights. So when he confesses, then he has to know what he's doing. The next one is the Sixth Amendment. Sixth Amendment has to do with right to a speedy trial, speedy and fair trial. Now, speedy is kind of an arbitrary term. Nobody, the defense included, wants it to go to trial right away. If I'm going to try to defend myself, I want to get my ducks in a row to prove, yeah, these are the reasons I didn't do it. Like, I need to line up witnesses to say I was bowling at the time of the theft or something. I wasn't even in the state. I was in Ohio bowling. Theft took place in Lansing. I wasn't even around. Okay, so the Sixth Amendment has to do with a fair and speedy trial. Everybody's has the right to have a trial of their peers, meaning just a cross-section of the community. So everyday average citizens will judge your guilt or innocence. Now, one of the Supreme Court cases that we do have to know, again, I don't think they're going to specifically ask a question about it, but you can utilize this in evidence, as you can the others as well, is Gideon versus Wainwright. Gideon versus Wainwright was the one that said, if you are accused of a criminal act, then the state has to provide you with a lawyer if you cannot afford one. Because really, it's not fair if I am getting accused of a crime and I can't afford a lawyer, and I'm like, I can't pay a lawyer, so I got to go in there and defend myself. I don't know how to navigate a courtroom. I don't know the procedures. I mean, it would be extremely hard for me to defend myself against a trained lawyer. That's not really fair. So Gideon versus Wainwright said, yes, we have to even the playing field. You have to have legal representation. The state will give it to you if you can't afford it. The last one is the Eighth Amendment that protects people against cruel and unusual punishment. So cruel and unusual punishment would be something that is out of the ordinary. So something that's way extreme for what you did. Say I dropped a piece of paper and they got me with littering and they're going to put me in prison for 30 years. That is way excessive. So that would be cruel and unusual punishment, excessive fines or penalties. Eighth Amendment protects against that. A lot of people feel like the death penalty falls underneath cruel and unusual punishment. The United States government doesn't agree, but some states do agree. So there are a handful of states that do not allow the death penalty, Michigan being one of them, but many states do, and the United States government does as well. The military also has the death penalty if something happens in the military. So these are some of the things that go into protecting people accused of crimes. If you have any questions, please let me know, and we will go over that stuff. If not, hopefully you guys have a great day.